Okay.
That's what this is called.
Yeah.
All right. Appeal 1046 District of the State of Florida is now in session. The Honorable Meredith L. Sasso, Chief Judge, presiding. All persons having business for the court draw near, give attention, and you will be heard. And God save the United States of America, State of Florida, and this. Please be seated.
Morning. Welcome to the oral argument session from the 60th at the Ninth Circuit. We have two cases up there, third case on the docket. I would just remind everybody to please silence all cell phones. We are live streaming this on YouTube for everyone to see. Please be mindful of that as well. And with that, we will call our first case. Oh, I'm sorry, I introduced my colleagues here. To my right is Judge John Sargel. And to my left is Judge Jerry Smith also. So thank you all for coming over today to accommodate our. All right, and the first case today is 23-1143. It's Bowers versus St. John's River Water Management District in Orange County.
Take the support.
I have 5 minutes reserved for your vote.
Your Honor, as you know, this appeal challenge is the issuance of a permit to Orange County, the St. John's Water Management District. If the court will indulge me, I think this is backbeat enough case that we need a little bit of, imagine we need a little bit of orienting to what's going on with these water systems. And then after that, I would like to explain a critical point the court really shouldn't lose sight of as it analyzes all arguments and issues in this case. But first, background. So the permit and issue sought approval for 2 improvements to a pre-existing water management system that was installed by the county in 2010. And I will show you the first improvement is a rock check dam. I'm going to circle it so you can see it. Just located there. Second improvement is an outfall pipe way down at the bottom here. So these 2 improvements connect to this larger system that the county installed in 2010 without a permit. Now, 3 months before the county submitted its permit, its application for the improvements to the pre-existing system, Judge Munyon issued 60-page circuit plans to resolve nearly 10 years of litigation between Mr. Bowers and over this 2010 system. And 2 of the rulings are particularly important to this appeal. First, Judge Munyon ruled that the county violated Mr. Bowers' federal and state constitutional rights by using taking his land in 2 discrete ways. One, the county committed a per se taking by installing portions of the system right around here. So I should have told you, this is Mr. Bowers' property, and this is the lake right here. And Judge Munyon found that when they were installed, the county was installing this portion of the system, that it was on Mr. Bowers' land and was per se taking. That was the first basis for the taking ruling. The second one was that the county committed another taking by diverting the historical flow of water in the region by taking 2 watersheds that are, lack of a better description, one's up here, one's over here, and routed both of these watersheds through the system. And for the first time in 2010, shooting all of that water through Mr. Bowers' yard into the lake. And it's also important to remember these findings from Judge Munyon are attached. The whole judgment is attached to the county's permit application. So it's right there for the agency to see when it fields its application. Oh, pardon. To the second issue that's really important. Judge Munyon also found that the county actually has it blown up right here. That the county, when it installed this large 2010 system, didn't have a permit and failed to provide for pollution abatement. And we can read specifically, because it's important language. Here's what Judge Munyon found. Bowers seeks to require the county to inspect, maintain, pollution abatement as required by various laws for the drainage across its property and the lake. Bowers has a clear legal right to require Orange County to provide back to the law of the Water Management District and for the statutes. Orange County failed to do so when installing the larger drainage pipe to the drainage easement, causing or threatening irreparable harm. Equity is served by requiring compliance with law and requiring inspection, maintenance, and pollution abatement in the drainage easement and lake as required by law. The upshot there is they failed to get a permit and they should get a permit. So that's the background. Here's the aspect of the case I don't want the court to lose sight of. Put yourself in the agency's shoes. the ALJ issue, same thing. Your task, your primary reason for your legal existence is to ensure the safety and protection of Florida's waters. And you get this permit application, and it is a finding from the circuit court judge that was issued 3 months before the permit application was submitted. It finds that this very permit applicant violated your own agency laws and the statutes that govern you. What is hard to imagine is that there would not have been any type of meaningful discussion about what those findings meant. What did they mean? What was Judge London talking about? We've got the same parties, we've got the same system that this permit application is seeking improvements to. This is the system that Judge London is talking about. How was there no discussion whatsoever about it's a superior court and it's just ignored? And that would have been strange enough. What's even more bizarre is that the agency and county successfully convinced the administrative law judge that there should be no mention that Mr. Bowers was precluded from relying on these findings, discussing them, referencing them, anything. So this is
Is there any legal principle?
the finding here? Absolutely.
Just the, yeah.
So, Florida Admin Code Rule 62-330.302, subsection 2, states that when determining whether an applicant has provided reasonable assurances that the permitting standards of this chapter are being met, the agency shall consider the applicant's violation of any rules adopted pursuant to Chapter 373, efforts taken by the applicant to resolve those violations. Makes it directly relevant, and it means the agency had to consider that claim. So our position is, and in our motion for attorney's fees, we've argued that the agency committed gross abuse of discretion, and this court should reverse. I don't know which issue it reverse. But whatever issue it chooses, it should find that there was a gross abuse of discretion, because the affirmative effort to sweep under the rug the culmination of 10 years of litigation in circuit court in the same place on a clearly relevant matter is frankly impossible to understand.
So each of the issues raised, to my view, turn on this issue of whether the ALJ considers simply the prior permit, or whether it's just looking at the wrong thing. What improvements in the ALJ proceeding, is that right? Does it all turn on this issue, or if we kind of assume for the purposes that Orange County did have ownership and not entitlement to improve those aspects of the then do any of the arguments still hold, or does it all turn on kind of this?
The failures to obtain a prior permit?
Yes.
No, not necessarily. Our second argument of the briefing is dedicated to even if you ignore what happened in the circuit court. The simple fact is the county never provided reasonable assurance. This system was not going to impact adversely Lake Florida, which, by the way, connects to another lake, which I can't remember the name, but that's Lake Apopka. It's a big important natural body. So, you know, I don't think it just depends solely on the interplay between the space.
Not necessarily the interplay between the circuit and like whether this initial project was done correctly, whether that initial permit needed initial versus the limited issue that the ALJ determined, which was whether was consistent with the administrative codes.
No, I mean, like I said, I think even if you don't consider the failure to get a prior permit, the law is clear that you have to get the permit even if it's after that permit. That is there's a form, 62-330.060 subsection 1. And it's in the record citation is 1862. This form specifically asks, when you're submitting a permit, it asks whether an applicant is seeking a permit for operation of an existing unpermitted work. That box should have been checked. There's a legal obligation to check that box if that's what applies, and it really does. There wasn't a permit before. So whether you frame it as they failed to get a permit before, or they should have gotten it then, maybe it's one and the same. But it's it's just the general lack of a permit for this very extensive, comprehensive water management system.
So what's your response essentially that this is a ownership dispute, which would be in the jurisdiction of the circuit court, and that any issues as to whether Orange County failed to obtain an
That's the first 10 years is all about. And that's exactly what we did. So no, I mean the question is whether or not the agency should have forced the county to obtain a permit and to account for the entire system. Does that answer your question?
Yes.
Ultimately, Your Honors, the case really boils down to three things: failure to get permits for structure built in 2010, failure to get reasonable assurances regarding pollution abatement, and ignoring the court order. The failure to get reasonable assurances on the pollution abatement is particularly difficult to understand. I mean, even if you set aside the agency's main function, which is to protect forest waters, my client, Mr. Ballard, on his own dime, financed his own testing. He's worried about his lake, worried about pollution flowing into his lake. And he did his testing, used an entity that the county uses from time to time to do the same sort of testing, and found that there was a heavy pollutant load going into the lake. In the face of that evidence, the county, the agency, still did not force any sort of testing or reasonable assurances for this larger system, which is hard to calculate. And the only argument in the briefing presented by either party in opposition to this idea that you cannot narrow the scope arbitrarily is that, well, this is what the county said they were looking for, and all we can do is, field them as they come. And that's just not, that's not support. There's no support for that in the law. And in fact, the law is the opposite. And I think I already referred to 62-330.3022, which says the agency shall consider previous violations. And in addition, you've got Florida statute section 373.4131 subsection 1, which explains the purpose of the permitting rules is to govern the construction, alteration, and operation of any stormwater management system, dam, impoundment, reservoir, pertinent works, or any combination thereof. So the statutory scheme for permitting specifically envisions a combination of works to form a larger water management system. It needs to be permitted. I said this wrong.
We are 10 minutes. Please support. My name is Linda Bramer from Minnesota. I'm assistant county attorney. This court should affirm the water management final order issuing the environmental resource permit legal circle alcohol regarding the proposed project. According to 1851 left, which is a little cockeyed right now. The proposed project consists of replacing the existing buried 15-inch pipe, which is in yellow. It's hard to see, but it's in yellow. Replacing that with and replacing or removing the existing asphalt swale, which is in green, labeled in green, and the existing shed and tank, which is in orange, and putting in an underground 18-inch with a shallow surface swale, records at 18 3-ditch bottom inlets, which are shown on the diagram, and a baffled end wall, which you can see, which is in blue at the very end. In addition, the 18-inch asphalt pipe and baffled end wall are to be installed entirely within the drainage the R1411. According to our 1853, which is D3 of the Science and Civil Construction, the project includes an upgrading of the check dam, which is shown here. You can see that the upgrading of check dam is west, it's on Lake Older Drive, west of the western. The purpose of the upgrading check dam is to slow down the flow of water and to promote infiltration for smaller storm. Record site 14 and 16. The increased infiltration will allow more stormwater to be absorbed into the sea. The area map shows that the area includes Lake Older Drive as part of the area. In this case, the burden of proof shifted to Mr. Bauer pursuant to section 0.569 friend 2E. In that statute, basically allows the Orange County and the water management to make a prima facie case of impact by moving into evidence the application and the district's technical staff and the permit. So in this case, the burden of persuasion was on Mr. Bowers to prove his case in opposition to the permit by preponderance of the evidence, and to prove that Orange County but the standards for schools in the that's a record page 1655. The recommended order specifically holds that even under the pre-2010 scenario, the administrative law judge found that the preponderance of the evidence of this project meets the standard for issuance of the environmental. That's at page 1415 of the record, paragraph 1. The recommended order. In this case, substantial competent evidence supports the administrative law that defines the fact. As for actual determinations, this court is prohibited from its judgment without in assessing the weight of the evidence. Additionally, regarding the record, judicial review of any agency action shall be confined to the record. That's pursuant to section 120.68, friend 10, and friend 4. Regarding expert testimony, the record shows that Mr. Bowers tried to follow the testimony of David Russell as an expert, but his testimony was given little weight. He's not a licensed expert.
I think I guess part of the dispute here is, I guess, the scope of the ALJ's determination. What's your response to the argument that the ALJ unnecessarily determination here to only get the proposed construction? Whether this entire unit,
In terms of the amended final judgment, the amended final judgment does not state that Orange County meets the amended final judgment doesn't mention any of the water management rules. It doesn't mention the applicant's handbook. It doesn't mention auditing criteria, which is required under the applicant's handbook. 3.2. It doesn't mention permitting requirements or permitting thresholds, which are also in the record, referring to the testimony of this water management district to explain that you have thresholds. Before you need a permit, you have to trip the threshold. So many square feet of impervious area. So there are thresholds. Permit is even required. In addition, there are exceptions to permitting, such as maintenance or de minimis or grandfather, and also the amended final judgment never addressed those. The The amended final judgment did not evaluate or recognize application for a permit application for the circuit court is a permitting agency. And the decision to grant or deny a permit is as well as the decision to grant a proposed project is also a governmental function for trying. Here, looking at the final judgment itself, what we see is Mr. Gowers only focuses on the very last paragraph, last sentence of paragraph 48. But in 47, the amended final judgment specifically denied injunctive relief for increased discharge. The amended final judgment at page 186 said that Gowers has not met his burden. Regarding his request to join the use of the drainage easement, the circuit court held that Gowers has not met his burden. And that was in both counts 6 and 7. The negligence count and the pollution claim for the first 3 paragraphs of the adjunct. Regarding paragraph 4, that's the paragraph that Gowers focuses on the general statement of law, which is not an injunction. It does not meet specificity requirements of 1.610. It is not an injunction. It does not state that Orange County needs it. Regardless, the ALJ did consider scenario 1, you know, from the record that Mr. Mack from CPM on the pre-scenario, pre-2010 scenario, the existing scenario, and then the third scenario was the scenario where the condition. The impact of the 407.5, contrary to the allegations initial brief, Mr. Bowers did evaluate the impact of the 407.5. I wanted to drive by looking at if you compare the output. And as you know, that the ALJ found that it's still met the standards issues.
It was just looked at in the context of insulation, I guess.
You know,
In the context of
the scenario 1 specifically did look at the system without like the 407 foot I like one drive. Wanted to know that there are actually 2 different pipes. There's one pipe on Lake Ola Drive, as you'll see from this one, and another pipe on Lake Ola Circle that's in the southeast corner of Lake Ola Circle. It's more like the driveway culvert. It's not a pipe that goes from Lake Ola Drive to easement, but rather it's only a shorter pipe. And that's what's out there in the field is contrary to what is in the amended final judgment. The amended final judgment describes a 15-inch polyethylene pipe beginning on Lake Ola Drive, which is top right, down Lake Ola Circle, making 322-degree turns to discharge in the drainage. As you can see, there's no such pipe that covers that length. In other words, that is the imaginary pipe. The imaginary pipe described in paragraph 30 of the final judgment is not in. And if you look at the construction plans on page 1713, you can go this one. 1713. It's a little difficult. You can see that the site and field construction plans do show drainage or ditches along the eastern side of the lake.
So council, I know this was raised in the reply brief, but opposing council mentioned it today. The Florida Administrative Code Rule 62-330.302 subsection 2, that the agency shall consider applicants' violations of any rules adopted to reset and efforts taken by the applicant to resolve these violations. Their position is that it was error for the administrative judge to allow prior evidence of habitual violations that should have been something discussed. I'd like to read the chance.
Orange County disagrees with the opinion or the interpretation that they made in final judgment found that there's no evidence that the ALJ found of the action by the line of terms of the amended final judgment. There's nothing that requires Orange County to file a permit or for the type of one that you would try, let alone an imaginary. So Orange County would defer to the water management district on the.
Thank you.
Our phone's just having a question. After you introduce yourself, you could just pick up. She talked about. You can answer that and then.
Yeah, that's applicable for the appellee. As for roles and issues that require change. There is no evidence of violation per se in the for the amended. Additionally, the agency and Orange County, they went out to Mr. Bauer's property. They spoke with Mr. Bauer. This is at page 919 of the transcript. He describes that Mr. Bauer had concerns, and so to address those concerns, the district capacity that would have estimated runoff conditions that existed in the area prior to 2010. To consider whether any changes were done in 2010, and the facts show that they did not. The ALJ did consider the model scenario, but still concluded that even under scenario 1, the proposed project still meets the condition. And this is in the record at 14 and 15, and it's also in the transcript at 9:29. The ALJ also gave the appellant a chance to prove his own version of the scenario, but the appellant's experts chose not to run any modeling in that scenario. So the appellant failed to carry his burden under and he failed to offer countervailing modeling evidence to dispute the pre-2010 conditions. This is a factual finding. Weighing of the evidence by the ALJ. Additionally, the ALJ found, and this is in the record of 1413 and 1415, the same volume of water will flow to Lake Ola after the project is built as it did prior to the project being built. And it will be the same discharge rate of flow. This is called a pre versus post analysis. It's the currently existing state. Also, scenario 1 looked at pre-2010 state versus the post-development state, and found that that modeling met the district. I can keep going, or if you have one. Did I answer your question, Joseph? I believe the water quality is not relevant to this environmental resource. There is no water quality analysis that is required for this permit because there is no activity that would increase the loading. Examples of this would be the placement of impervious surfaces or a change in land use. And Ms. Dewey, the district's expert engineer, described this at page 916 of the transcript. She talked about having a 5-acre site that's could have trees or grass. There's no development, so there's very little. If someone comes in on the 5-acre site and they put a retail center, you can have parking buildings, you increase the volume of runoff, and then you decrease the pollutant load that are coming off. So if that had been the case, if the county had installed a road, changed the land use, or done something that would increase the pollutant loading, then water quality sampling would have been required. Water quality analysis required. But that did not happen in this case. In addition to the appellant arguing that the decade-old work should have been included, there was also argument that a portion of the roadway should have been included. And there was a factual finding that the roadway had been there since the 1940s. So their argument is kind of a slippery slope. How far back is the agency and the ALJ supposed to go? And the ALJ found that as a matter of law, the existing condition is the condition that's in place when the permit application is submitted. And that was the appropriate scenario. It was called scenario 2.
that the ALJ considered for issuance.
What is your response to essentially the race judicata, the aspect of race judicata? To see if the parties here is similar for equity purposes.
The district was not a party to the circuit court case. So I know I'm kind of repeating this stuff, but the amended final judgment from the circuit court case does not require Orange County to obtain a permit for this nation works. And what Helen's asking this court to do is essentially add language to that final judgment that does not exist. Because the district was not a party, race judicata or collateral estoppel. Additionally, the issues are completely different. From what we can tell from the amended final judgment, and it is in the record in this case, it was considered by the ALJ before he found it to be irrelevant. It has to do with the taking for the easement. It has to do with diverting the source of water, but those issues are not relevant to this permit application. And Judge Early found that the historical flow of water in this area is not relevant. That's in the record of page 14 and 9. And really it's because our rules center around impacts to a receiving water body. So if you look at 62, 330, 301, sub 1A and sub E, the agency looks at impacts to the receiving water body, and here is impacts to lake water. And the ALJ did talk about the 46-acre catchment area. That is where the historical drainage exists in this area, and he found it to be not relevant. And that's at page 14. Additionally, the third-party permit challenge is not really the proper vehicle to attempt to enforce the as Judge Early advised the involvement in the record of page 50, if petitioner has a dispute as to whether some element of Orange County's drainage works are consistent with the circuit court guidelines, those issues can be taken up with the filing of a petition to enforce the judgment in the circuit court. Judge Early also advised appellant at page 16 to 17 of the transcript that if appellant wants to bring his concerns about the 2010 district, his remedy is through a different section. Finally, this court should not award fees to appellant. The agency action does not rise to a gross abuse of discretion here. And examples of that would be where an agency acted intentionally to do something that it knew to be wrong, or where an agency acted arbitrarily. And the fact that this case did not rise to that.
Council, if I can interrupt you for just a second. It seems that if I'm understanding correctly, the argument as to why the circuit court final judgment should not be agency level because of your position that there was no finding of code violation within the correct.
That's part of it, Commissioner.
So if you look at paragraph 48, page 14 of the court states, and this is in its findings section. I'll give you a second.
I'm sorry. Thank you, I'm ready.
Okay, so keep it to the bottom of page 14 of the final judgment, and then final judgment, paragraph 48. The last few sentences there state Bowers has a clear legal right to require Orange County to abide by its code, the law of the Water Management District, and statute. Orange County failed to do so when installing the drainage easement or threatened. So how would you assert that that's not binding?
Having a I, first, the first sentence, having a right to have Orange County. That's kind of a statement that goes without saying. It's a legal requirement. But as far as Orange County failing to do so and stop the drainage pipe to the drainage easement, our reading of this is that it ties in with the takings point. It doesn't mention any rules of the water management district that were violated, and it does not require Orange County to come to the district to get a permit. Any other questions?
Thank you very much.
Thank you.
This idea that Judge Smith, I think you just pointed out exactly what's going on. There's clear language from Judge Mike that says violated the water management district own laws and regulations by pollution. That could be a reference to nothing else besides the failure to get a permit. That's it. And it's also, I mean, you know, if the agency or the county was accepting applications from a point, and there's a box that says, you know, have you ever committed a felony? And someone checks the box, yes. And then in the line underneath it says, please describe, and it's blank. You know, would you just say, we're not gonna worry about it. We don't, okay. We're not even gonna ask any questions, we're not gonna inquire. I mean, the lack of specificity of the specific laws that were violated. I mean, first of all, pollution abatement is mentioned, it goes to a specific permitting requirement. So I think that's troubling, the idea that you get a circuit court judgment in an administrative tribunal that says someone has violated, the same permit applicant has violated your agency rules, and just because the circuit court didn't mention which rule they violated with a citation to a reg, you're just going to ignore it. That seems ludicrous.
And so I think they presented it as a factual scenario. Excuse me if I'm messing up terminology, but basically scenario 1 to scenario 2 and ALJ. That scenario 2 here.
So that all goes back to scenario 2 and scenario 3 are all based on this premise. It's okay to take this narrow, you know, have this narrow scope for what we're trying to get permitted without, you know, addressing the big elephant in the middle of the room, which is this pre-existing massive water management work. Scenario, and you know, the entire time, the agency's argument, the county's argument was that anything before 2020 just wasn't relevant. And I've noticed at least that there's not too much of a defense of the relevance argument, which was carried today all throughout the proceedings. And we have to be really, really careful, because the county and the agency are both touting this scenario 1 that this gentleman named Brian Mack presented to the ALJ. That scenario 1 is, without exception, the exact case that was squarely rejected by Judge Mike.
So I guess it circles back to my initial question, which is, do we have to, for the purposes of your argument, accept that the circuit court order applies the administrative proceedings and or factual determinations and the circuit court order? How does that administrative? Or is there some kind of substantial argument? Circuit court order aside. Reach the same result in administrative proceedings.
I think so. I don't think you can, I think there's a separation of powers problem. And, you know, the relevance really was how this all started. I don't think you can, to the extent that the competent substantial evidence are findings that are squarely in opposition to what the circuit court found. That cannot be competent substantial evidence. I don't think it matters if issue conclusion applies. I mean, without any sort of analysis or explanation of what happened in the circuit court case, what these findings mean, there's no reason analysis. I mean, how do you even decide whether something is relevant or not without exploring what the rule is talking about? You know, So we've got this whole imaginary pipe argument from the cabinet. Pipe's not imaginary. It's right. It's on the official exhibit that the county submitted in the administrative proceedings. And Judge Munyon found it exists. And I mean, that's hubris. It's a lot of hubris to come and say, never move for rehearing on anything that's circuit court, take it to the field, never argued below that the pipe is imaginary. The county is saying that Judge Munyon, and a really important finding, was imaginary, didn't exist. Again, the circuit court is a superior court to the administrative tribunal. And we have a serious problem if you can do a complete end around what happened in the circuit court for 10 years of litigation, a lot of attorneys in an administrative tribunal. And this idea that there's some excuse to not have to get reasonable assurances about how a large, the big water management works, the ones that created in 2010, they sought to improve this permit, that there would be it's okay to just not check if there's going to be any adverse impact to the waters. That's their function. They're the cops, they're the water cops. Like if they're not doing this, especially after a circuit court has teed up perfectly for them and said, we've got a problem here. We have a problem. There's a constitutional emphasis on protecting forest waters. There's statutory emphasis. There's executive order. 3 or 4 different sources of law that say this is a really big deal. And the circuit court in the founding said, this is a really big deal. We've got a problem with the lack of pollution. And in the face of all that, to say, we don't have to do anything because all we're seeking is to get permitted are these 2 little improvements, as if these aren't improvements to this pre-existing system. It's never been permitted. It's not okay. And it completely strips my client's victory in the circuit court. That's not fair, and it is not good for the water.
You say there's an argument basically about updating and moving the water to a different area that change the water quality.
Well, I mean, that's ludicrous because in the circuit court case, Judge Munyon specifically found in paragraph paragraph, I believe it's 40. Judge Munyon specifically found that the water, high volume of water, a significantly higher volume of water, based on the 2010 structures that were built, was going into Lake Owen. Because previously, in one watershed, the water came down on one side, but the other watershed that was later combined when they built the 2010 structures, that went into ditches. It didn't go into Lake Owen. So we've got a much higher volume of water going into the lake through a completely different path. There's the Hall case. The cases are cited in the briefing that says you divert the historical flow of water, you must get a permit. And they diverted the historical flow of water and increased the volume dramatically and never did any testing. And I hope the court sees that that's as problematic as we do. And it's Judge Munyon. Thanks, Josh.
Since the appellant was given an additional 1 minute to do
No, I think we've extended time on both sides. Our next case on the docket is 23-1179, Nazar, Virgin County.
I'm Lindsay Walton. The issue in this appeal is substantially narrower than the issue requirements you just heard for the agency appeal. This appeal is from a certain court order denying motion for entry of judgment. The issue is whether the court erred in concluding that a final judgment had already been issued. The answer is yes, the court erred. And you can see that error by straightforward application of the well-set definition of what a final order is. A final order is one that leaves no judicial favor done in the case. We're asking this court to reverse and remand an explanation to the trial court that no final order on merits of the circuit court case has ever been entered, and that the circuit court should conduct any appropriate proceedings based on the issues raised by the parties to get us to the final order on the merits. In the briefs, we've shown 4 ways that you can ensure that no final order on the merits is ever entered. And I'll run through those briefly and elaborate. The first way you can see that is that there's no language of finality. The second is that one of the orders the county relies on to show finality actually preserves jurisdiction for further judgments herein, and that reservation of jurisdiction has never been returned. The third is that there is absolutely no order even dealing with count 1 at all, and no order effectuating the party's settlement by either that count or the other set of counts. And the fourth is that the language used in the orders the county relies on shows that the trial court left specific work to be done on count 7 in particular. And that is the count where we obtained the findings that were being discussed earlier about the county's violation of harbor management laws, the Orange County Code, and the Florida statutes, and Mr. Bauer's right to have them comply with that law. Now, while I've summarized the 4 ways we show there's no final order, it's important to remember that these are all just different ways of attacking the same question as to whether there's a final order that leaves no judicial labor to be done. Under the Florida Supreme Court's case in SLT Warehouse versus Webb, the test for finality is whether the order in question constitutes the end of judicial labor in the cause, and nothing further remains to be done by the court to effectuate a termination of the cause as between the parties directly.
Let me start with the declaratory judgment counts. I'm looking at 45. Why isn't it enough to say that an order granting declaratory judgment and then steps, for example, for declares Orange County has been trade issues?
Your Honor, I'm willing to concede on the counts of declaratory judgment that the court finished its work on those counts, as the court said, the court might endorse the declaration. But in order to have the final appeal order on the case, the court would have needed to have had an order dealing with every count case and have that language of finality that tells people, I, circuit court, am truly finished with this case, and now it's ready for review.
So which count specifically do you think are remaining?
Count 1, which is a trespass. That's one of the 7 counts. There's no order discussing that. Count 2, private nuisance, another one of the 7 counts. No order exists dismissing that. We've got count 6, that is for negligence and injunctive relief. That's the tort part of that was settled. No order dismissing the tort. The injunctive relief part of that actually dovetails into count 7, which is the 4, 3, 12 thing, where the court made the finding we've been discussing so much. That Mr. Bowers has a clear legal right to have county comply with the law. The court, count 7 is analogous, the way the court handled it is analogous to when a court grants a motion for summary judgment or grants a motion to dismiss, but doesn't take the next step and actually enter this judgment or enter the dismissal. But it's actually more than that here, because it is clear that Judge Munyon intended to grant injunctive languages Mr. Bowers has clearly the right, equity is served by requiring compliance with that law, but she didn't take the next step and say, Orange County, here's what you need to do and by what date, which is how you complete an injunction under Order Rule Civil Procedure 126.
So on the tort claims, there's the argument that there's this notice of settlement in the court minutes, that there's the pretrial stipulation that in case those claims are settled. What's your response to that?
My response is that those accounts are settled, but there's no court order dismissing them, which is required to effectuate dismissal. The fact that the parties outside of court have settled the claim doesn't complete the court's labor. The court has to take an extra step and enter an order of dismissal. And you can see that from Order Rule Civil Procedure 1.0, which tells you the ways that a claim can be dismissed. There is such a thing, of course, as a voluntary dismissal. But if you look at 1.420A, it shows that the only way that you dismiss a case without a court order is by something that the plaintiff or something that the plaintiff signs in his mind. We don't have that. And that's important. I mean, it's a loose end that wasn't tied up, and it may seem like a thing, but the law governing what a final order is tight. And the courts are very strict about it for a reason, because the Constitution says the appellate courts have the authority to review final orders. And when this court gets an appeal from an order, the first thing it does probably is look to see if this actual is it final and is it final. If it's not final, the court is very strict about that and takes it back. And I submit to you that if Mr. Bowers had tried to appeal this order earlier, that exactly happened. Try though you may, look in the record, you will find no language of finality saying that this case has been finally determined by a certain court. You'll find an order discussing those pending tort claims. And most importantly, you will find no completion of the court's work regarding that injunction.
And so going to the injunction, what do you think was necessary for the court to do in order to make this?
Under Rule 1.610C, the court needed to give Orange County specific direction as to how to bring it into compliance with the law, and needed to give Orange County a time frame to do that. It appears from the record, particularly the hearing on the first motion to enforce, that Judge Money trusted Orange County to know what to do and to go ahead and do it. Orange County represented to the court that it was working on that. We imagine Judge Money denied motion to enforce, so she didn't say time. But it became clear during the course of these proceedings, which were unfinal, that Orange County did need some more specific instruction, and that was required under Rule 1.610C. And the reason for it, I guess, is because parties do need that instruction in order to have their orders.
And so why wasn't that a basically a deficiency in the order issue that would have been necessary?
Because there's no language of finality in the case. Because the court, if there had been language of finality for the court saying, I finished with this count and with the tort counts, then that could have been, and then we could have taken up an appeal on the merits, and that could have been argued. But as it stands, we have no final order, so there's no basis for treating it as a deficiency because there's actually not a final order to find a deficiency.
So does that argument hang on this paragraph 52 of the court or jurisdiction? There's nowhere the order doesn't say, that's to fulfill these issues. So there's nothing on basically where it plays further with this that issue other than this reserved jurisdiction.
My argument doesn't hang entirely on that, but that is good support. Reserve generally jurisdiction to serve further. Not tie that to any specific account. They certainly didn't tie it to a 3D issue. That's one way that you can see that court order wasn't finished. And then the other argument that I raised to you about the lack of language and finality and again, it's not necessarily the judgment. dot all the T's and cross the I's. It's what does the language of these orders do? What is that's how you decide what they want.
No.
Okay. So yeah, just from the way to determine if the order is fine is to look at the language of the order. In this, we don't even have an order that Orange County can point to and say this is the final order of the case. If there were a final order of the case, it would be very easy to identify that. Here, Orange County, it started out in the circuit court and cobbled together several different orders and not even orders, but documents filed by the parties to say, here, we've got a final. And then on appeal, we show that that's not sufficient, and the target kind of moves in the answer brief. They start identifying additional documents, either like that pretrial statement and so forth, and say, no, this is really what shows. This moving target shows you that there's not a final. And again, it's the reservation of jurisdiction and further judgments that's never been retracted. It's the lack of language of finality. The case law says from all the DCAs, you have to have, so this one, not yet. That says you have to have unequivocal language of finality. That's how important news that it's time to review the order. The final order is going to be put on merits. We don't have that. I essentially challenged Orange County in the initial brief to locate some language of finality. Their answer is, of course, well, you don't have to have magic words. That's true. You don't have to have magic words. You don't have to have specific phrases, but you do have to have some language to show the judicial labor in this case. We don't have that.
And what's your position as count three?
My position is that count 3 is wrapped up, but again,
There may one link to it, right?
and if there are no further questions, that is my argument. Statement but I'm happy to.
You reference on the other side about this holding decision. Decision. That you mentioned notice of settlement being treated as a notice. How do you distinguish that case?
I mentioned that. Oh, don't mind. I'll take a minute to pull it up. My reply brief.
It's page 10.
Okay, so the Colvin decision was an unpublished court order that I think it was probably 1 or 2 sentences. We are dismissing this petition and treating a notice of settlement as a voluntary dismissal. That order was not. That was an order issued by the Supreme Court in I was going to say an appellate proceeding, but a review proceeding. It was not an order entered under the rules of civil procedure, which are a different world. So the circuit court's requirement for how you enter a dismissal is laid out in Rule 120. The rules of the Florida Supreme Court operates by are different. They're in, Rule 9. But additionally, we don't have the language. The Supreme Court's order doesn't tell us what the language of the voluntary dismissal is. It doesn't tell us if the party signed it. And so the Colvin case or the Colvin unpublished order doesn't really tell us. We don't know what was okay.
So your point is the notice of settlement, it's an appellate level settlement, therefore. So she. Is that correct?
Yeah, sure. That's one layer. The second layer is we don't know what the notice of settlement said or who signed it. Questions?
Thank you.
Thank you.
Okay, please report. Linda Brenner, says. With the entry of the June 2020 final judgment as to count 3, the inverse condemnation all claims were adjudicated or resolved. As this law recognized January 2020 final judgment suspended by March 2020 amended final judgment. In addition, it was a final orders to the injunctive ruling. The first claims were settled, and the final judgment is to count 3 resolved the remaining condemnation.
Specifically, I think it's pretty clear before the claims were settled, but where we have a final on the tort claims to be also to.
What we have is we have the notice of settlement filed by March 29th. We have the joint pre-trial statement filed March 3rd. Which was
So the notice of settlement, it just says that these things are.
correct. The joint pretrial statement was signed by page 4864.
And again, that says that the proclaims are settled.
It does.
Okay.
And specifically, also during the pretrial conference held on March 9th, page 49. The court minutes of the pretrial conference court rules as follows. The pretrial was held, the parties confirmed they have settled the court. Record page 4925. Notifying the court of a settlement was required by the trial order phase 2 before the case was removed from the docket. That's at record page 6790. The trial order for phase 2 required the parties to notify the judges by email on the case being settled and stated the case will not be removed from the pretrial docket. Documents necessary for closure of file. Mr. Bowers, in his motion for a separate final judgment, recognized that under Rule 1.420, it's not necessary. Under Rule 1.420, it is proper to just file the joint stipulation of dismissal. Orange County submits that
Was there ever a joint stipulation?
Your Honor, there was the joint pretrial statement. There were representations of the court.
So we have to make believe that the notice of settlement is equivalent to a notice of a joint stipulation of dismissal.
Travelers indemnity versus Walker at 40172nd. In this case, the court entered an order enforcing the settlement, which the court held was a final. The order enforcing the settlement required Walker to deliver to travelers a title insurance and a stipulation of dismissal for a certain amount of money. Upon motion, Walker's motion to vacate was granted in the order. But on appeal, the appellate court held that the order, given that it was filed after the time frames that were. The appellate court specifically held that by the terms of Rule 1.42082, it actually simply by finding a stipulation. Here, no order required for Rule 1.420, which means that there's no further court action necessary. In other words, the judgments, including the final judgments to count 3, ended the judicial labor in this case.
So as to the traveler's decision, to the extent that opinion treats this notice of settlement as a stipulation of dismissal or why should we adopt a rule that a notice of settlement is the notice of stipulation of dismissal?
It's not just a notice of settlement, it's the notice of settlement that figures statements signed by the parties and representations to the court. The court ruling that said that the parties settled. In addition, it's also the post-judgment. The parties understood that the case was final. They filed motions for attorney's fees, and those motions for attorney's fees 1.520 basically states that 1.525 it requires the parties to pay fees and costs just for 30 days after judgment. And it's 30 days after judgment, concluding a judgment, which judgment or notice concludes the action listed by party. Not only do we have the motion for attorney's fees, we actually have the hearings, and I guess it's also the record.
I think this happens pretty frequently. We did get appeals, the parties that understood their mind. they file a notice of appeal, we review it. We determine that there is in fact no language. And the way it allows us to make proceedings in the back. Why does the parties understanding?
I mean, for example, in this case, it's not just the parties' understanding, but the parties' understanding is indicative of what the orders meant, what the parties thought and how it was perceived, and certainly that is circumstantial evidence. So the parties' treatment of the orders as being filed is definitely, it's not dispositive, but it shows that the orders were filed according to what the parties said. And not only that, Bowers repeatedly filed motions to enforce, and in his third motion to enforce the amended final judgment as to count 7, it was denied. And it was denied, including the finding from the trial court that Bowers failed to timely from the trial judge's final order. So by not appealing the third order, or the order denying Mr. Bowers' third motion to enforce final judgment. Not appealing that was in August 2021. He basically agreed to the judge's finding of ruling that Bowers failed to timely appeal. And he should have known at that point that at least at that time, in August 2022, and that's how the problem. And he did not appeal. The standard of review on motions to enforce as under Fair versus Rather, the 273.7 for 221, 222.
You would agree that the issue of whether or not there's final whether there's
for one order against him. In this case, I do agree with that questions of law are reviewed in the
I think Ms. Lawton made the point that a typical finality analysis turns on language of the order.
Well, in terms of language of finality, I think the court's ruling in its minutes, first, an order of dismissal is not required under 1. So it's not necessary to grant a final judgment on a separate piece of paper as requested. Under Rule 58, you are allowed to ask for a piece of paper. But in state court, there's no such rule. Appropriate to decide a case in pieces and have a series of final judgments. And in this case, that is what we have in terms of finality, especially should have been confirmed with the order denying Mr. Bowers' third motion to enforce. And since you don't need a formal order of dismissal for the tort claims under 1.2, claims are dismissed with prejudice because it's not required stipulation before due. And the other counts have been, there's clear language of finality was conceded regarding the declaratory judgment claims as well as the inverse. Like the only counts that they question, apart from the tort claims, are the injunctive relief claims. The injunctive relief claims decided in the amended final 20. They did not to ask for clarification regarding paragraph 48, which doesn't grant injunctive relief. It doesn't specify, but it doesn't specify what should be done. This one cited to statements made in response to their the third motion to enforce that it was made. There were a number of reasons argued in that case, including the existence of a 2018 permit that was brought up, including the lack of specificity in the final judgment. I think also And that the amended final judgment didn't indicate that anything was to be enforced among other reasons. So that transcript was read, it shows that there were many reasons for objecting to Mr. Carter's third motion to enforce. It was the judgment to enforce, which was denied by Judge Mungan. And Judge Mungan did, according to Mr. Bauer, say, I'm denying it at this time. And at this time does not mean that I'm objecting. At this time, maybe I'm denying the motion now, as opposed to I'm reserving the motion.
What's your response on count 7 to the argument that there was additional language needed in order to indicate finality in light of the kind of lack of issues relating to, and then also with the I think it was paragraph 51.
I think the judgment was clear that it was a final order on the injunction. Council is not in order granting or denying motion to dismiss or granting or denying motion to summary judgment. It was an order entered after a non-jury trial in December 2019. It was an order entered after the court directed the parties to submit proposed final judgments. That the injunctive relief council did not need additional. There was a sentence that was, so clear, or it shows that Mr. Bauer did not meet this burden. In addition, paragraph 48 did not even address the fourth problem of injunctive relief adequate remedy law, which was mentioned in April 8, 2020 transcript, that having an adequate remedy in law is an element. On top of that, if you look at the language in paragraph 48, it does talk about the pipe to the drainage easement. So there's actually two separate pipes, and three if you include the imaginary pipe, but there's two different pipes. There's the 407-foot pipe along Lake Ola Drive, and then there's the driveway culvert with the circle pipe. There's no pipe from Lake Ola Drive to Lake Ola Circle. So the amended final judgment in paragraph 48 doesn't talk about the pipe on Lake Ola Drive. That was part of the drainage flow, I think, which was denied. Injunctive relief was denied as to the ordinance. So in terms of that paragraph that the plaintiffs or Mr. Bowers has so closely looked at, it really only talks about compliance with laws regarding the pipe to the larger pipe to the drainage east, which is only the driveway culvert. And that pipe is not in the field because it doesn't last. If you look at the record does show that in another transcript that and I have the record so I can read it, but it does state that Judge Money was asked, did you mean to say Lake Ola Circle, not Lake Ola Drive? She said in the transcript that no, I meant that. And so she, even over the objection of Mr. Bowers, she said, no, we don't disagree with what you have to say, but she specifically said that I'd be happy to do that. Regarding the reservation of jurisdiction problem, the March 2020 amended final judgment was also reported where it specifically ruled that the court will empower a jury to determine the issue of full compensation for taking the Mr. Bowers property in severance damages, which are the subject of this order of taking. So that order of taking, that portion of the county propounded a proposal for settlement, which was accepted by Mr. Bowers in the final judgment was to come through this measure. So when full compensation for the order of taking was resolved, that resolved that issue as specifically identified in the March 2020 amended final judgment. The parties agree that the determination of the issue that is. And regarding the reservation of jurisdiction, we have one in August 2021 that was denied and said specifically that Mr. Bowers did not choose to appeal So at the very least, finality occurred when the third order on motion to enforce was entered, that Mr. Bowers did.
Council, Council, if I may, on the travelers case, that case involved an order enforcing settlement. Do we have that here? Do we have those facts here in order enforcing settlement? I've heard you mention it.
No, Your Honor, there was no actual motion to enforce.
So wouldn't that make it distinguishable? I mean, as I think through the order enforcing settlement, that would effectively be the trial court entering, adopting, ratifying the settlement of the parties. An order denying enforcement, how does that equal the same thing as? How is that case not distinguishable from something that should apply here?
Well, the case does hold, specifically that the contention that the subsequent formal order of dismissal was necessary to terminate the action was basically was not necessary. I mean, that is the point. That is the reason that case was. The parties can just, and Orange County Defense have notified the court of the settlement and represented orally, maybe not in writing, and the court ruled that the party said it was settled. And albeit it's not a traditional joint stipulation of dismissal, there was a ruling, a representation to the court that removed from the docket is required by the trial orders. So yes, it's not exactly similar. Again, 1.420 does state that a formal order of dismissal is not required. And because of that, the cases that say that you don't need magic language, that if you look at whether judicial waiver is done, that judicial waiver is done because the court does not need to enter that final order of dismissal. And here we have multiple, not just the notice of settlement.
Councilman, I apologize for cutting off. Even if we were to find the travelers applicable in this case, despite distinguishing factor that there's no order, we settled the agreement. How many DCAs?
I have not researched. But I have not. There are other cases too, like a Department of Children reference a document. And in that case, the court 50 CA held that that was a fine. So the court reasoned in that case a jurisdiction ought to be controlled primarily by what a document does, by what it was called. And here what we have is when.
Council, can you give, is that in your brief? Did you cite that case in your brief?
Yes, I did, Your Honor.
Okay, what's the site?
It's Department of Children and Families. It said 939, 7 seconds, 226, 228, 228, 29, or 50 day 2006. In that case, there was a document entitled Court Minutes on page 1 and Order on page 2. It was signed by a judge and filed by the clerk. I felt that was a final Department's certiorari petition. And the court reasoned again that the jurisdiction ought to be controlled. Here, what we have is we have the court ruling. We have in the minutes, and what the document did was remove it from the trial docket as required by the trial.
Did you say that you cited that in your brief? I'm looking at your table citation. page.
It's on page 25.
Which would-
Any other questions? Thank you, Council.
Thank you.
Well, I'd like to start with town side. One thing that is clear from the images paragraph just one was finding that Mr. Bowers was entitled to. It is also clear that Judge Mundy did not give specifics of what that ruling was. So in order to finally to resolve that claim, Judge Mundy needed to give those specifics for Rule 1.610, or needed to say expressly, unequivocally, the judicial labor on this count is done in one way or another, and that never happened. And all you need to do to make a determination on this finality issue is, of course, to look at the orders that were issued by the court, as we discussed thoroughly. But I would be more than happy for you to look at the enforcement proceedings. I would invite you to look at the hearing transcript from the first motion to enforce, in the record at page 6,666. That's then the afterward again, but that's in the middle of the hearing. It is very clear from that hearing that both sides were arguing to Judge Mundy that the order did not specify what Orange County needed to do. It is also fairly clear that the likely reason Judge Mundy did not grant enforcement was that Orange County told Judge Mundy that they were looking for the permit that was envisioned by the amended final judgment, and that they were providing that amended final judgment to the agency so that the agency could make a fully informed decision on the permitting request. At the end of the hearing, Judge Mundy said, "I'm denying the motion to enforce at this time." The second motion to enforce came about, I think it was about a month later. There was no hearing on it. It was denied, presumably because Judge Mundy was still trusting that Orange County was going forward and providing the agency that order and doing what was envisioned, although not expressly stated in the amended judgment. So it's clear that, paragraph 48 wasn't intended to do something. Judge Mundy wasn't wasting everyone's time by saying Mr. Bowers has a clear legal right to have Orange County follow the law. Judge Mundy was anticipating that Orange County would do something to bring itself into compliance with the law, and she just never laid out those specifics. Orange County argued that, I guess, that we should have appealed from the August 2021 order entered by Judge Weiss. And by the way, the third ruling on the motion to enforce was the denial was by Judge Weiss. And his ruling was that he did not believe he had the ability to add to Judge Mundy's order. As the arguments throughout this appeal show, that was an error as a matter of law because there has never been one entered. I believe there was some discussion about how we needed to appeal from that order, but appealing from a motion to enforce is a different thing from appealing from a final judgment merits. The motion to enforce was a motion entered during the pendency of these proceedings. We didn't have to appeal from that. We could wait until the final order on the merits was entered, which had. Regarding the EG case that was just discussed, that case thoroughly is in support of Mr. Bowers. I cited that in the initial brief on page 24 and discussed it again on page 13 and 14. In EG, what the court was looking at was whether the fact that an order issued by the court also contained minutes meant that it wasn't an order that could be challenged through a search warrant. The whole issue in that case was whether the existence of the word minutes on it changed what the order was. In our case, Orange County is trying to rely on minutes as an order. The EG case shows that minutes are not an order. An order is an order. And as far as the reservation of jurisdiction, I would just invite you to again look at the language of the amended final judgment. The reservation is to enter further judgments. It says nothing about count three. If it was limited to count three, Judge Monday would have said that. Moving on to Rule 1.420. Travelers is contrary to the plain language of that rule. We have a rule that tells courts what you do when there's a settlement and how to dismiss a case. That rule had to be followed by the trial court in order to effectuate dismiss. Orange County keeps arguing that you can have a dismissal without an order. Well, that is true, but only under the terms of that rule. And the terms of that rule were not met here. The only way, if you look at the plain language of 1.420, the only way you have a dismissal of account without an order is if the plaintiff files a voluntary dismissal or someone files a stipulation of settlement, I believe it's called, signed by both parties. That is not in the record. Therefore, at a minimum, the tort counts are still pending with some judicial labor that needed to be done to wrap it up. There's an appeal order, but of course, we don't have just that. We've got this significant work left to be done on 7, as all parties needed to be done during that hearing on the first motion to enforce. And I'll say it's hard enough to figure out when an order is final. And so there's no reason to add to the rules to create some different outs or make the order final. But we'll say you have to have an order of dismissal, and the case law thoroughly interprets final order in language. It's something you can point to in the record and say this is the final order. We don't have that. If there are no further questions, I would just ask this court to please reverse and remand to show the trial court that there has never been a final order on merits, and that the motion for entry of final judgment should have been granted. Any proceedings necessary to resolve the issues being raised should have been conducted and should now be conducted, so we can have a final merits. Fully give Mr. Bowers the relief that.
Now I see you back there with the,
Okay, people, okay.
just want to make
Just
sure.
watch the proceedings.
All right, in that case, we'll give you.
Well,